be seated. We have 3 cases on the docket this morning. We're going to take them in the order that they appear. I'd like to take care of a couple of housekeeping matters first. First, I understand we have a number of students from Florida State and Florida A&M. You're welcome, and I'm glad you're here. I'd also like to welcome Judge Ployce from the 5th District, who's sitting with us today. We're very honored to have him here with us today. And we will take a break after the first case, 15-minute break, and we invite all counsel to have coffee with us in the Commons. Are both parties ready on the first case? Okay, you may proceed. Okay, Mr. Maffa, I don't normally do this, but I'm going to say that I don't know how else to phrase this, but in this case, I'd almost like you to address us as if we're second graders in the area of taxation.
Yes, sir. Yes, Your Honor. If it pleases the court, my name is Joe Maffa. I represent the appellant, Colgate-Palmolive, in this case. I'd like to reserve 5 minutes for rebuttal.
Okay, I'll try to remind you, but you have the clock in front of you.
Thank you, Your Honor. For purposes of our guests today, I just want to mention that this is an exciting case regarding corporate income tax. I'm sure that's why everyone showed up today from their classes. Despite what the Department of Revenue argues in this case, it's a very simple principle of taxation that we're dealing with. It's a question of whether or not domestic dividends can be treated more favorably to taxation of foreign dividends, or if that's what's happening in this case. The complexities in this case are...
Okay, well, let me try to break it down. First, let me just understand, you're not saying that the Florida Code has to mirror the Internal Revenue Code, are you?
No, Your Honor, we're not.
My understanding under the federal code that there are 2 ways of dealing with foreign dividends.
That's correct.
One is the tax deduction method, which I'll call option 1, and then we have the tax credit option, which is option 2. Would that be fair?
That's correct,
Fair
Your Honor.
characterizations? Okay. And I understand your argument. And the easiest way to do this might be to go to page 6 of your reply brief, where you have 2 charts there, Company A and Company B.
Okay.
What you have there is the tax credit method. Is that correct?
That's correct, Your Honor. That's what was elected on the federal tax return.
And excuse me for being slow, and I'll give you more time because I'm trying to frame the questions properly. If you take the tax deduction or the tax deduction method, option 1, Florida would treat you the same exact way as you would be treated under the Internal Revenue Code. Is that correct?
No, Your Honor, because what you deduct is not the dividends, it's the tax from the dividends.
I thought, and help me here, because I thought as far as option 1, Florida strictly piggybacked the federal law.
I don't believe so, Your Honor. I thought, I didn't go into
okay, help me there. Explain why it's different.
But the way I understood it, I thought option 1 is where you have the option of deducting the taxes associated with the dividends. But just...
Okay. No, I understand that, but I thought as far as the actual effect, Florida pretty much piggybacked the federal law as to option 1.
I thought it was different, but I could be wrong on that.
Okay, maybe I'm wrong, but help me if I am, because I thought it was.
I think the issue you're getting to, though, Your Honor, is more in general that since the taxpayer made an election to take a credit versus taking a deduction, should Florida law, because they took the credit, be safe from constitutional challenge, that they're not discriminatory. And, you know, this is a separate return that was filed by the parent company, by Colgate-Palmolive. The purpose of the deduction is to eliminate double taxation. And so if the federal provisions allow for a credit, I think, again, because they piggyback here in Florida, Florida does not allow for a credit. They have to have some meaningful relief for the taxpayer when a credit is taken. Because if they don't, it's still going to be discriminatory.
Okay, but your argument goes to that the foreign credits or the foreign dividend deductions are being treated differently than the domestic dividends from another state, correct?
Correct.
In Florida, if someone takes a domestic dividend, are they entitled to a tax credit for the domestic dividend?
No, Your Honor.
For taxes paid in another state?
No, Your Honor, because the dividends are completely removed from taxable income.
Okay, I understand that. But I'm trying to understand if you allow deductions under option 1.
Right.
How you're and basically how under option 2, just because you're not allowed to carry over, how that's treating you in an unfair manner or an unequal manner.
Well,
if you can't get credits for domestic dividends.
Well, again, the domestic dividends are taken out of the equation when you get to arrive at taxable income. The foreign dividends are not. So to equalize the playing field, you have to be able to take the foreign dividends out of the equation also if you're going to take the, when you take the credit. So for purposes to equalize, what you're saying is they have this gross-up method for federal tax purposes where you, in effect, calculate the taxes that were hypothetically paid on these foreign taxes, on these foreign dividends, and you get a credit for that, but then you gross your income up for that also. And that's the Section 78 IRC credit that's taken. Most corporations take the credit method because it's more beneficial. And the Supreme Court addressed that in the Kraft, Iowa decision in their footnote, why, that most corporations do take the credit method. Again, I wasn't expecting a question. Maybe I should have been on the deduction method. I was more prepared to discuss the differentials. That if you take the deduction method, or that you should not be required to take the deduction method just because of state taxes here in Florida. Again, it's discriminatory if you're taking the credit and Florida doesn't allow a credit.
But doesn't that argument go more to whether the Florida method is somehow inconsistent with federal law rather than you're being treated unfairly versus domestic dividends? Well,
there's always going to be differentials between Florida law and federal law. It piggybacks to the greatest extent possible. But there's differentials in items, and that's why they have the modifications. And the modifications, in the first year of the deductions, the modifications are identical for both federal and state. There is no discrimination in the first year. It's the second year when if a loss is created because of those modifications.
I understand that the carryover of losses is the whole issue here.
Correct.
If Florida allowed you the carryover of losses, it pretty much mirror federal law, and we wouldn't be here. I mean, that's the whole issue.
That's correct, Your Honor.
And I understand that. I'm just having difficulty understanding how that puts the foreign dividends in a position of inequality with the domestic dividends.
If in the situation where a taxpayer elects to take the credit, because they've taken the credit, their income is grossed up for it, and therefore Florida does allow the deduction in the initial year for the dividends and for the gross up. And so everything is on par. It's the carry forward method. They do provide for it. So I guess you're saying, why would that be discriminatory because we're not allowed to carry that forward?
Yeah, that's one.
Well, again, I think you have to look to Kraft, Iowa. It was a separate return, and Kraft, Iowa says that, and that was an example where the footnote in Kraft, Iowa was for a credit, and they said that you have to treat dividends equally, the domestic dividends and foreign dividends. And what Kraft, Iowa didn't go to was the extent, well, okay, you have to have this equality but it never talked about what you do on a carry-forward basis. But how could you have how could they be more or less equal if you didn't allow the carry-forward like you do for the domestic dividends? Domestic dividends, because they're subtracted out of federal income to begin with, never become part of the equation.
Counsel, I have a couple of questions. You and opposing counsel seem to differ on whether this is a facial challenge or an as-applied challenge. There's some law student. You might want to just comment on what the difference is and why you've taken a position that I think you have here that it's a facial challenge.
Well, I think in our brief, we kind of, and opposing counsel, I think, correctly pointed out that we identified it as both in different parts of the brief. And we believe it can be argued as both. A facial challenge is when you look to the statute itself, or in this case, it's really the rule that we're objecting to, whether the four corners of the rule is unconstitutional. The Kraft, Maryland case addressed specifically that issue on a facial challenge, and they held that you have to look to the overall taxing scheme of the state to determine whether or not it's a facial challenge would apply. If it's not a facial challenge, it would be an applied-to challenge just to this taxpayer.
Well, it seems to me this is an as-applied challenge, isn't it?
Well, again, if that's the position you take...
doesn't make any difference which position we take. Is that what you're saying?
Well, I think we can argue both. And our brief was not clear on that, and the opposing counsel did clarify that or pointed that out. But I think it can be argued as both. Again, Maryland tax court said it was a facial challenge on virtually identical facts. In this case, if the court determines that it's a as-applied challenge, the issue there is whether or not sufficient evidence was in the record. And opposing counsel went in and indicated that they didn't believe that there was. I think the record is very clear from the very first agency action that was issued in the notice of decision, which is on page 7 of the notice of decision, which is record page 25. They identify the foreign dividends. And throughout, we had a stipulation of facts which identified foreign dividends and the foreign tax credit, the gross-up amounts. The record is full of indications that the foreign tax dividends deduction and the foreign credits were taken into account.
You're down below 4 minutes.
Thank you, Your Honor. I'd like to reserve it for rebuttal. Thanks.
May it please the Court, I'm Clifton Cox. I'm an Assistant Attorney General, and I represent the Appalachia Department of Revenue. I think part of the confusion stems from the lack of clarity whether this is an as-applied or a facial challenge. And I think an illustration might clarify exactly what the two sides are contending. Suppose a hypothetical Florida company has $1 billion of foreign dividend income and $1 million of domestic taxable income. Its receipt of the $1 billion of foreign dividend income in Florida has no Florida tax consequence. It's as if it doesn't exist. Appellant contends it should be allowed to subtract the $1 billion of foreign dividend income from the $1 million of domestic taxable income and carry the resulting artificial loss forward into future years to avoid all income tax. The Foreign Commerce Clause has never required such pyramiding of tax benefits for untaxed foreign dividends. Yes, Your Honor?
Counsel, opposing counsel's reply brief has a little bit simpler hypothetical there that pretty clearly demonstrates, at least on paper, that there's discrimination there. Can you elaborate on that?
Yes, Your Honor.
Where is it? Is it misleading, wrong, or what?
It overlooks the effects of the federal tax credit, the effects of appellant's own election to forego deductions to claim the tax credit, and the potential deductibility of those dividends. Because under the Federal Income Tax Code, Section 245, the foreign dividends may qualify for the very same deduction domestic dividends could qualify for under Section 243. if this is a facial challenge, appellant is challenging the constitutionality of Section 220.13, subsection 1B1A.
Okay, you're playing bingo too quickly for me.
I'm sorry, Your Honor.
You're playing bingo too quickly for me. 245, 243, 242.
Okay.
Just say the law, we'll figure out
Yeah,
what it
try
is.
to
Okay, Your Honor.
go into a little bit of an explanation of where you're headed.
Okay. Section 245 permits a deduction of certain foreign dividends. Section 243 permits a deduction at the federal level of domestic dividends from subsidiary companies.
Okay.
Yes, Your Honor.
Let me interrupt because I'm going to get to that chart for a second.
Yes, Your Honor.
If somebody uses the tax credit method,
Yes, Your Honor.
which I've called option 2, is the chart on page 6 and 7 of the reply brief, Company A and Company B, accurate?
It overlooks matters, Your Honor, and can be misleading for that reason.
Okay, what matters does it overlook?
It overlooks, first, the potential deductibility of the foreign dividends. That chart would indicate the foreign dividends cannot and are not deductible, but they may be. Secondly, it overlooks the effects of the tax credit. Your Honor, if this is a facial challenge,
How does it overlook the tax credit where it appears to me, and maybe I'm missing it, that on the second page it specifically has the tax credit? Let's see here. I thought it did. Okay, excuse me, I thought it did. It's here somewhere. Okay, go ahead. I'm sorry.
Counsel, before you get back in, you made kind of an interesting statement in your brief to the effect that if you disagree with us, then tell us how to fix it.
yes, Your Honor,
Have you got any thoughts on how we ought to fix it if we don't agree with you?
there are,
I must say that's one of the first times I've ever read that in a brief, but it caught my eye anyway.
Your Honor, it is the very first time I have ever included something like that in a brief I have written. The problem here, again, goes, first of all, the first question has to be whether this is a facial or as applied challenge. If it's a facial...
Let's assume that we conclude, and I don't know how we're going to conclude this because we haven't conferenced it yet, but let's assume that we conclude that it's as applied unconstitutional law under the Kraft case.
Okay, Your Honor. In that situation, the court would have to compare the relative burdens on foreign dividends and domestic dividends. The Kraft case and the other cases cited in the brief, the Japan line case was one, recognized the difficulties states have when you have foreign source income. States cannot tax companies without Florida nexus. We cannot now, in the Kraft case, the state taxed the foreign dividend income, did not tax the domestic income. Florida excludes all foreign source income from taxation, so it is not included in any tax base.
Why wouldn't the fix simply be that you would allow them to have a loss carryover?
Because, Your Honor, that would provide a double or actually a triple tax benefit and a pyramiding of the tax benefits for untaxable foreign dividends. Now,
you got to
the way
explain
that works,
that to me. You lost me with that one.
I'll try, Your Honor. Under both federal and Florida law, taxpayers generally can deduct expenses for creating taxable income. If the income is not taxable, they cannot deduct the expenses. If they have already deducted those expenses and the income is not taxable, those expenses have to be added back pursuant to the flush language in Section 220.13 1B 2B. That flush language makes it very clear that if there are, in that case, those expenses must be added back. Your Honor, we would contend, though, that it would be improper for the court to rewrite Section 220.13 1B 1A. Any remedy should come from the legislature.
Okay, help me here.
Well, how would the legislature, my question, I'm not suggesting that we ought to rewrite it because that's judicial legislation, but how should the legislature repair it or fix it?
Your Honor, that is for people who are much brighter than I am. The problem we have in Florida...
Well, I don't know whether we...
Thank you, Judge. The problem we have in Florida is the state of Florida, at the time of the Bernard Egan case, did tax foreign dividends. At least the constructive foreign dividends, what's called Subpart F income. That was okay, because we also taxed domestic dividends. Now, though, under current law here in Florida, all foreign dividends, whether actual or constructive, are irrelevant. Florida does not tax foreign dividends at all. So now the appellant contends that although that foreign source income has no tax consequences in Florida and is totally irrelevant on the taxation side of the equation, they should still receive a tax benefit to offset taxable domestic income in future years. The Commerce Clause has never required such a thing. The only case that we have ever found that would support this theory is the Maryland Kraft case, which was a specialized trial court decision that was never appealed, and the court never addressed the fact that the foreign dividends were...
We understand it's not precedential, but it certainly has some persuasive logic in it anyway. Wouldn't you agree?
Your Honor, it overlooks matters that I think are very important. First, it overlooks the fact that foreign dividend income is income, not loss. That the appellant was able to deduct, or potentially deduct all of the foreign dividends in addition to the tax on those dividends, that the appellant affirmatively elected to forego those deductions and claim tax credits instead.
Well, it seems to me, even though you argue that it's overlooking things, the result comes out the same, doesn't it? I mean, it overlooks things, maybe, but in the end, when you compare the two scenarios, it demonstrates discrimination between the two methods.
Your Honor, I believe that because it overlooks those special benefits foreign dividends receive that are not available for domestic dividends, it should not be a persuasive
What are those
case.
special benefits it purportedly overlooks regarding domestic dividends?
Well, first, the foreign dividends have no tax consequences in Florida. Domestic dividends may. Foreign dividends are entitled to receive a federal tax credit. Domestic dividends are not. Foreign dividends may be deductible under Section 245, just as are domestic dividends under Section 243. One big problem the Court may have also is if this is an as-applied challenge, the record is not sufficient to show any discrimination when you consider all of these other issues. The tax returns are not in the record.
But, counsel, regarding that matter, did the appellant not waive any right to make an as-applied challenge? The appellant did not raise a factual dispute, correct?
That's right, Your Honor. The appellant, we stipulated in the proceedings below to what each side considered relevant facts. The appellant apparently was assuming this was solely a facial challenge, and the record just is not sufficient to permit any evaluation or weighing of the aggregate burdens on domestic and foreign dividends to have a valid as-applied challenge. Now,
What exactly is the appellant alleging in your view? I'm going to ask you to do something unusual since you say you did it in your brief, and that is, how would you characterize the appellant's argument regarding the discriminatory treatment of tax credits? Obviously, we understand, I think, that, or I see your argument that they could have taken the deduction. The deduction would have created the net operating loss. They wouldn't be here today. Their argument is, you can't force me to take the deduction. That's my choice. I took the tax credit. Under federal law, that tax credit creates a net operating loss through, I assume, the gross up. And that net operating loss under federal law carries over into future years. My understanding of their argument is I'm entitled to that net operating loss carryover in Florida. And domestic companies in Florida, the appellant is arguing, do get some type of benefit that he's being denied. Is that a fair characterization in your view?
I don't believe so, Your Honor. I think that it really boils down to whether a taxpayer can have a heads I win, tails you lose, have my cake and eat it too position.
But, I mean, his argument is that the state company, the domestic company, is getting a heads I win, tails you lose position. Is that, do you dispute that?
Yes, Your Honor. I would agree, Your Honor, that that is what they are arguing. I would disagree if that is an accurate characterization.
And is that because of your point that domestic dividends are taxable and foreign dividends are not taxable? Or do you argue that the credit is?
I didn't say that foreign dividends, foreign dividends in Florida are not taxable. Right. They are excluded entirely. On the federal level, they may or may not be, and the record does not indicate whether they qualified for the Section 245 deduction or not. It's one of the problems of the record, Your Honor.
But you're entitled to take credits against your income under federal law. And I guess the question comes down to, if you have that entitlement under federal law, at that point, based on the chart on page 6 and 7 here, it appears that domestic dividends are getting a benefit. If we say that, you have to allow them to take the credit, the tax credit, is your chart on page 6 and 7 correct?
It overlooks material information the court has to evaluate to consider whether it's a valid as-applied challenge. If you leave out those other details, it's accurate. It's just incomplete and therefore misleading.
You mean such as the non-taxability of foreign dividend income or foreign dividends under the federal code, right? Is that the
under
omitted
the Florida
fact?
tax code.
Right, because the Florida tax code takes your federal income level as a starting point, right?
Yes, Your Honor. And appellant does not contend that Florida should tax the foreign dividends or that Florida should audit the foreign subsidiaries that pay those dividends. Appellant claims that it should have the benefits of the federal tax credit and that Florida should pretend that it deducted those dividends under Section 245. Do I have 1 minute?
Still have a minute.
Okay, thank you, Your Honor. So, Your Honor, appellant asked the court to rewrite Section 220.13 1B1A that simply says there shall be subtracted from such taxable income the net operating loss allowable for federal income tax purposes. If that statute is unconstitutional, net operating loss deductions are improper. Now, deductions are a matter of legislative grace, and Florida treats companies the same whether or not they have foreign dividends. The Florida net operating loss is simply the product of the federal net operating loss and the Florida apportionment factor. All of those state law additions and subtractions in Section 220.13 1A and 1B are irrelevant. So the question then is simply whether a state may use the federal net operating loss multiplied by the apportionment factor to determine the applicable state net operating loss, which is what Florida does. There is no case law in this country other than that Maryland tax court, the specialized trial court case that the Department's aware of, that would indicate that this should be done.
Thank you.
I thank you.
Thank you. The year of origin is not the issue, as we've identified before. It's the year of utilization. And they seem to say that you can deduct it in the year of origination, but it's when you carry it forward that they have the problem. They're saying that no court has gone that far before. I don't know if, other than the Maryland case, I don't know if there are any other cases out there. But I think if you look at Kraft, Iowa clearly states that there must be some type of parity between domestic dividends and foreign dividends. And again, going back to the federal structure, domestic dividends are deducted right off the tax return, the starting point, the federal taxable income, where foreign dividends are not, unless you can deduct them, which, again, I indicated before I wasn't sure because we didn't take that. We took the credits. Because the federal law provides for either method, again, Colgate took the credits, Florida law should provide for equal treatment or some type of balanced treatment between federal and state law. And that's really, I think, what the key issue is. Florida does not have a credit. They have to have some mechanism to equalize the tax ramification to these foreign dividends, and they don't. If they provided a credit, that would be fine. If they just said, we won't allow any deduction, net operating loss carry forward for domestic dividends or foreign dividends, that would be fine. There would be no discrimination. But it's because domestic dividends are included in the tax in the beginning line number. They've already been deducted. Foreign dividends are not.
Well, your argument is that it's the tax credit that creates the problem, right? If you had taken the deduction, you would not have been treated differently than a domestic company under Florida law, right?
And again, I mentioned before, I'm not sure that if you can take the deduction for it. Opposing counsel seems to say that you can. So if that would be correct.
Okay, well, we won't go outside the record. Then your argument is Florida has to provide the exact same mechanism that your company chose to take the tax credit and provide that net operating loss that can carry over year after year after year. That's your argument, right?
It doesn't have to be the exact. It has to somehow or another equalize.
Equivalent.
Yes.
So you, I assume, don't dispute your opposing counsel's example then when he says your company has $1 billion in foreign dividends. It has $1 million in Florida income, taxable state Florida income. Your argument is that Florida has to give your company the equivalent credit that you received under federal law that creates a net operating loss that carries over. So you have no tax liability in the state of Florida under your proposed interpretation, I guess pretty much indefinitely, right?
Well, no, Your Honor, because the foreign dividends would have been included in the income. That, I think, was the fallacy with his example. If you had $1 million of income for Florida, that would have already included the $1 billion of foreign dividends.
Okay, let me,
and the gross up.
May I
Yes,
ask if it may take more time? The hypothetical company has $1 million in income, domestic United States income. It has $1 billion in foreign dividends from Germany.
Right.
Let's even take it a step further back. The $1 billion in dividends your company took, let's assume they paid $250 million in German taxes on those dividends, right?
Okay.
You took a credit for that, not a deduction, correct?
Correct.
So your income for this hypothetical purposes would have been $1 million.
Well, $1 billion plus the gross up amount of the credit.
The 250 million.
Right.
Sorry.
So
1.25 billion is your gross up income.
Correct.
And then walk me through why his example is wrong.
Well, in Florida, if you've taken the credit for federal purposes, you'd get a deduction for the $1.2 billion, the $1 billion of income plus the gross up amount, and you would arrive back at the $1 million of income, which you started with before you took into account the foreign dividends or the foreign gross up amount for the credit. So it's not, because again, there's no credit here in Florida. If Florida, again, this would be a legislative issue, but if Florida would want to allow a credit similar to the federal, they could do that also. We would start at $1.2 billion, and then we would be allowed to take a benefit. But all we're asking for is since the $1 million in your example started off already excluding domestic dividends, all we're asking is that the same thing occur on the foreign dividend side. And the domestic dividends, instead of being a $1 million profit, let's say it was a $1 million loss, those losses would be afforded the treatment of NOL, carry forward. It's the treatment for the foreign dividends when you would deduct them that would not be afforded that treatment, and that's what we're saying is discriminatory.
Thank you very much.
Thank you.
Court will stand in recess for 15 minutes. We ask everybody, or the lawyers, to join us in the commons for coffee.